So we're here to talk about artificial intelligence and the law. And just to set the stage a little bit, as lawyers, we have to think about artificial intelligence from a number of perspectives. So increasingly, we're offered tools that purport to be artificial intelligence for us to use in our practice as law firm practitioners or in-house counsel. And they purportedly help us search through data, understand facts, maybe draft contracts. Dean will talk more about what he's seeing. And they promise to improve our speed and accuracy. And we have to consider whether we should use those tools or need to use those tools. Separately, as in-house counsel or outside legal advisors to business clients, we have clients that are increasingly building products that are using various kinds of algorithmic technologies. We have clients who want to buy and sell those kinds of technologies or companies that make those types of technologies. We have data that we might be using to train those technologies that we need to protect. And we have disputes that we need to prosecute or defend. And then as lawyers for the government, we have an additional role as an administrator of justice with a calling to incent change where we think that's warranted. So when we think about artificial intelligence, we have to think about it in all of these different contexts, and we'll explore those today. And we have to bear in mind both the law and the importance of the role of law, and our professional responsibility as lawyers, because we are bound by a set of legal ethics rules that govern our practice. So we have a great and talented panel today to talk about these issues. I would like to briefly introduce them. I cannot do justice to their credentials, which are lengthy. Dean Harvey, immediately to my left, is a partner at Perkins Coie in Dallas and is co-chair of the Artificial Intelligence and Machine Learning and Robotics group at his firm. He's a transactions lawyer, focuses on technology transactions and privacy and security. And he is, I guess, an engineer by training, a computer scientist, and started his career developing artificial intelligence and various algorithmic systems. So thank you. Amy, to Dean's left, is a partner at Davis Wright Tremaine in Washington, D.C. She has a practice across energies ranging from healthcare to energy to e-commerce. She advises on security and privacy, appears frequently before regulatory groups on behalf of her clients, and advises AI platform, some of the biggest AI platform companies on the different legal issues that are affecting or may be affecting them going forward. Amy started her career as a technologist and had her own technology consulting company where she worked on security design and implementation for many years before becoming a lawyer. And we have Justina Rivera, who is a senior associate at Harris Beach in New York. Justina is a litigator, trial lawyer, trying complex torts, toxic torts, and medical malpractice and commercial transactions. She serves actually now as outside counsel to the city of New York and does trials on their behalf. And prior to joining Harris Beach, she worked as a branch chief, a borough chief for the city, running their torts unit and litigating cases around New York City. And Justina began her career as a prosecutor in the sense that she worked for the New York City Administration of Children's Services, prosecuting parents who were abusing their children or alleged to be abusing their children. And she serves as a trial, a lecturer on trial advocacy at Fordham. And then John Barquette is a partner at Shakardi and Bacon in Miami. John is a litigator as well. He handles product liability, environmental law, employment law, and various commercial disputes. He's a professor teaching e-discovery at the University of Miami. And he has extensive experience as a special master and an arbitrator and an author, and writes about ethics and speaks about ethics frequently. And he is for the second time a member of the ABA's, the American Bar Association Standing Committee on Ethics and Professional Responsibility. And he will be bringing a lot of the ethical points into the conversation today. So thank you all very much. Everybody's got kind of a different perspective. I thought it was helpful for you to hear where people will be coming from. And I'm eager to get started. So I started with the concept of AI tools that are coming to us as lawyers that could affect our practice, that we have to choose whether or not to use. And Dean, I know you're very active at Perkins Coie in that regard and thinking about what to use and how to use it. Can you tell us a little bit about what you see?
Sure, happy to. We are leveraging AI tools, particularly to enable alternative fee arrangements. There is a lot of hype out there. It does require evaluation of these tools. I will say we're really seeing 5 big categories of tools for lawyers. The first is e-discovery. Clearly, AI has been using e-discovery longer than anywhere else for lawyers. It's the most mature use. And coming from e-discovery, the second category is contract review. So just as you could review e-discovery electronically, you could review and do due diligence on contracts electronically. What we've seen recently is a lot of marketing that you can actually do review of contracts as part of the negotiation process with AI. I don't think we're there yet, at least for the types of transactions we're working on, but they are working to enable that as well. Another category is legal research, much the way you go on Amazon and you search for an umbrella and Amazon says, well, maybe you want some galoshes too and a hat and a raincoat. Legal research and natural language processing, they'll look at your search and they'll say, well, maybe you should be thinking about these sources in these cases as well. And from that has come another category, outcome prediction. So you can run machine learning on dockets of courts and start to predict, for example, how long a particular matter will take in a particular court. And then finally, probably the scariest one for lawyers is expertise automation. And so much like TurboTax automates the filling out of taxes for lay people, you can automate routine legal tasks using tools like Neotologic. And so those are really the big 5 categories we're seeing currently.
And the tools that are you're worried about that are could replace lawyers. As I understand it, those tools are pretty much taking someone through a very routinized decision tree, essentially a synthesis of what the legal outcome would have to be that anyone would give as an answer if you knew all the right facts and had answered each of the questions.
It can be. We're also using it, for example, for intake. And so rather than having a lawyer interview a client for half an hour about what is this transaction about, what kind of data will be shared, is it going to be hosted, you can do all of that using a decision tree and much more efficiently and effectively freeing up the lawyer time and the in-house counsel's time as well.
Sort of like going to the doctor's office these days where you have to fill out your records on an iPad.
Exactly.
Okay, and your clients like that?
The legal department loves it. They are just absolutely thrilled because the process often, if you don't have some sort of intake process, is here's the contract, why isn't it done already? And so this forces the business to actually think about the terms of the contract, what it is they're doing, and actually suss out some of the problems before it comes to legal. So it's a much more efficient legal review process than it otherwise would be.
I can see that. Justina, go ahead.
I would also jump in. I mean, historically, minority groups have not had the same access to legal representation as other people. So I think automation could be a great way of at least providing a baseline, and then maybe the end of it is not necessarily this is what you do, this is what you argue in court, but then linking them to resources either in the community, legal services groups. I think that would be a really great way to use it as a tool to promote justice and really allow people to have access to the legal resources that are available.
Okay.
And you've seen that with Do Not Pay. I don't know if you're familiar, the 18-year-old in Great Britain who automated ticket protests and successfully appealed $16 million worth of parking tickets. And he is now working on expertise automation for lawyers. And the idea, again, is to help the poor who otherwise would not have legal services obtain legal services.
Are there limits on that, John? What do you think?
Well, of course, we get into, actually, one thing that Julie forgot to mention is that I'm also a professional clown.
That's true.
Aren't we all?
Yeah, but I really am a professional clown.
So I can say that to my ethics board.
Before I say anything about ethics, I had some props with me because I always wonder how audiences are going to react to whatever I say about ethical issues. So I'm making some animals. I'm worried that you might act like this animal, a little mouse, you're going to want to hide into a hole. Stay away from these problems. If you have children, you're welcome to come up and grab the balloons when I'm done. Or maybe you'll feel like this animal right here. And that is a little rabbit. You're going to want to run away from your problems as fast as you possibly can.
That's adorable.
Or maybe this animal. I'm sorry this room is so large, you won't be able to appreciate this trick. But what I'm going to do is I'm going to take this bubble that's at the end of the balloon. Hopefully your eyes are better than mine, you can see it. And I'm going to stick it inside the rest of the balloon. And I'm going to leave it inside. And so when I do this for children, this is the meatball inside the hot dog. But for this audience, this is the lump in your stomach when you find out that there's a grievance that's been filed against you because you didn't listen to what we're about to tell you. And with that, I will say that the unauthorized practice of law is obviously one of the issues here for folks that provide software to individuals to make your life easier. And there actually is some reported case law in this arena, and I think it's illustrative of why those that generate the software are going to win. There's a case out of the Fifth Circuit from about 20 years ago where the Texas unauthorized practice of law statute, now mind you, there is a model rule 5.5 that deals with the unauthorized practice of law, but a lot of UPL related regulation is by statute. And in this particular matter, it was a very helpful consumer product. The individual that developed it was found to be engaged in the unauthorized practice of law in violation of the Texas statute. The consumers in Texas protested. The Texas legislature changed the law, and on appeal to the Fifth Circuit because of the amendment to the statute, the case was reversed and remanded. But to illustrate the point, whether it's antitrust related, you may be familiar with the Supreme Court case from a couple of terms ago involving the folks that were engaged in teeth whitening, and the North Carolina Dental Board wasn't real excited about the competition. The problem was, of course, that the North Carolina Dental Board was made up of active practitioners who were losing revenues because the teeth whitening service providers were taking business away from them, and they weren't regulated by the state. And the Supreme Court, FTC, found that was a antitrust violation, an unfair competition act, and the Supreme Court affirmed. So, you know, when you're in this arena of generating products that work better for people, and it interferes with the opportunity for, say, lawyers to make money, and you want to encourage your state bars to regulate these folks under the theory that they're engaged in the unauthorized practice of law, you're probably going to lose. As I tell folks, whatever can be automated will be automated. The bar associations in the United States are way behind the technology curve here. The folks to my right are moving much faster than any bar association is able to move with rules changes, and that's true with the model rules or with any state rules. So yes, there could be UPL issues, but will folks get anywhere with it? Probably not. The LegalZoom case law, for example, generally has gone the way of LegalZoom. They're not now able to sell products that help people create corporations, write wills, The states in LegalZoom have reached an accord in effect as long as there's somebody licensed in that state working for LegalZoom that passes on the forms to begin with, the forms can be made available to the public. So you can see how easy it is to get around UPL statutes. So I don't think UPL is going to be an obstacle.
Would you say that the response to the statutes is effectively having a lawyer say at the beginning that the form is a good form to start with, and then people are giving, it's essentially self-help, right? They've
Right,
essentially
that's right, yeah.
declared it's not practicing law.
Yeah, if you actually, as I have, if you take a look at the actual settlement agreements between North Carolina and LegalZoom and South Carolina and LegalZoom, as long as there's an individual license in that state that says the form is a correct form, that's all LegalZoom needed to do, and then they can sell away and take business away from lawyers who otherwise would create articles of incorporation for you. But it's an automatable function. It's a task that can be performed by a computer once someone has generated a form. And you heard earlier today the reference to the use of cognition. If somebody has to think, you're not going to see a replacement with a computer. I've always told young lawyers that good lawyers are experienced, have knowledge and good judgment. The knowledge part of it can be done by a computer. Experience and judgment are always going to be the preserve of lawyers. But from an ethics standpoint, I mean, I can tell you there's great struggle among ethics opinion writers and rule makers in trying to figure out how you regulate a profession when automatable tools are occurring so fast. The things that Dean was describing, that Amy works with, that Justina works with, they're not going away, and they're going to get more and more sophisticated. Whether it's a contract review tool, lawyers, I mean, the questions that we'll get into later are, at what point does it become malpractice for a lawyer not to use one of these tools? And that's something that we should explore before the hour's up.
Definitely. Before we get there, I'm interested, Dean, you mentioned alternate fee arrangements. And can you just describe sort of how you're using the tools or what you're seeing? And Amy, your firm is very forward thinking on this as well.
Sure. Well, obviously, the traditional model is the billable hour, and clients have come to us. We're lucky to represent all of tech clients, and they look at things in terms of process, and they look at efficiencies, and they don't see the traditional billable hour model as meeting their needs. Every year, the rates go up. Every year, there's more legal fees. And they're saying, why can't you work with us, partner with us, and help us find ways to increase efficiencies? And so in terms of using these tools, personally in AFAs, one example is have a client, we did an alternative fee arrangement, they needed 500 contracts renegotiated for compliance purposes. Well, we could have had 6 or 8 associates sit down on day one and try and figure out what all these contracts are, because no one at the client knew. It's a huge company, 500 contracts, some of them are 10, 20 years old. You know, who are the parties to it? What are the companies? Someone has to sit down and figure all that out at the beginning. To do that with associates, depending on hourly rates, probably $50,000 to $100,000 just to do the initial analysis to get your hands around what you have. With a tool like Kira, we're able to do it in a couple of minutes. And because in that scenario, all those contracts are going to be renegotiated, the quality issues you showed with NIST are not really an issue for us. It's just getting your hands around it. So that's the type of efficiency that we're looking for. Automation, I already mentioned the intake process. So by driving an intake process, by extracting the information up front rather than halfway through the transaction, you create a much more efficient workflow. So those are the kinds of things on the transactional side.
Yes. Well, and our law firm, we have Davis Wright Tremaine de novo, where we have engineers and designers who are literally helping us on a day-to-day basis deliver legal product. One interesting piece of technology that our employment lawyers are using is looking at how for our employment lawyers, looking at the propensity of employee action, the propensity of employees to change jobs, the propensity of an employee who's habitually late to to be a signal for whether or not they're going to change jobs, and potentially intellectual property can leave the company. What we are finding, I think, which is the most interesting piece of what I do, is AI is permitting new insights that are a little scary, but that are allowing us to see data in a new and unique way. And particularly for myself, like as we are culling larger and larger data sets and getting insight regarding our employees, we have to be good stewards of that data. I am a partner in a cybersecurity practice. So we need to not only think about what data we have, but we also need to think about securing what data that we're outputting. And as our law firm is developing tools for employment insights, we're also part and parcel thinking about, okay, well, in the event that we're going to deploy this on our client site, we have to have these security parameters in order to protect the data lake that we would be calling data from, and the outputted data that we would have as we are developing these insights for our clients.
Just to follow up on
Yeah.
one thing you said, which I think is very important, is you've got to have a tech team if you're going to start using the tools now. There's really no way around it. There's no silver bullet. It requires a lot of work and configuration and oversight and quality control to effectively use those tools, and you've got to have that team.
And can I translate that into an ethical obligation? The 5 series of rules under the model rules, and the model rules are simply offered to the states for adoption. Every state has to adopt their own sets of rules, and that's what governs my practice. And I'm licensed in Florida, so the model rules don't govern my practice. The Florida rules do, and all of you are similarly situated if you're licensed in a particular state. But the supervisory rules are essentially the same throughout the country. And Model Rule 5.3 deals with supervision of non-lawyer assistants.
Yep.
That's ASSISTANCE, not NTS assistants. It was changed actually in 2012 from assistants NTS to assistants ANCE because of primarily the e-discovery world, where lawyers were using e-discovery tools, software. And so the issue is you have to be able to police as a supervisor whatever tools you're using.
Yeah.
And if I don't have that capability, the comments to the rule that were added in 2012 and have been adopted now in 35 states, my last count, you have to employ someone who is knowledgeable to help you satisfy your supervisory obligations. And what sorts of things do you worry about? Well, there's confidentiality, a 1.6 obligation. There was a change made in 2012, which again is roughly about 35 states have adopted it, that say that all of us now have the obligation to engage in reasonable efforts to prevent the inadvertent or unauthorized disclosure of client information. So you can see how that translates to the things you've heard Dean and Amy and Justina say already. So supervisory issues for someone like me, I don't have the technical capability to supervise the use of the tool. I would need to have somebody in our IT department do that. But now put me into a solo firm. Put me into a 10-person firm in a small town in Kansas or Florida. I'll pick Bartow, Florida. How do folks like that use tools and satisfy their obligations? They may not be able to afford the use of a software tool if the license charges are just too great. So you can see where these issues, you've heard from 2 very large law firms. And I don't know, Justine, how large your law firm is.
We use e-discovery.
Yeah, but you can see where as you're scaling up in size, you have the dollars to be able to spend as you scale down. From an ethics opinion writing standpoint, I can tell you, we think a lot about whether or not what we write in an ethics opinion has economic implications that will make the practice of law unaffordable for some small practitioners. It's a very difficult area to get your arms around when you think about the spectrum of types of folks out there practicing law and the sizes of the firms and the dollars they're able to spend to support the practices.
Yeah. And John, one thing that I want to dovetail on slightly, just because you're pointing out the small versus large firm distinction, we're having a hard time in very large law firms making sure that you have the requisite expertise to meet your clients where your clients stand. I know that you had mentioned confidentiality in the unauthorized practice of law, but also accuracy. So, I was dealing with a problem 2 weeks ago where literally we were dealing with data nomenclature issues. And unless you knew SQL, unless you've dealt with databases and large distributed hyper-threaded databases, you wouldn't have understood that we had a massive accuracy issue. A part of this wasn't an AI tool, it was a basic database tool. But the same issue is here, that in large law firms, we are hiring dual threats. And I am personally hiring dual threats, anyone who is also an engineer and an attorney, as fast as they can come out and we can find them. So it's not a small law firm and a large law firm issue. I think it's an entire practice of law issue.
Yeah, I would just add that while you need that staff, you cannot rely on the staff, to your point, Amy. To some extent, you still have to have a basic understanding in order to adequately supervise.
If you're in charge, you have to figure out how you're going to supervise.
Yeah.
Particularly on new tools.
Exactly, and also lawyers who, those who don't have their feet in both the law and as in technology may not even see the issue. So there's not a way to really get both that risk training, legal training, and technology training unless they've had the benefit of being there.
And I would just add also training the judges and the courts, because on the state court level, you would be surprised how many times you go into court and you're arguing about, someone preserving the metadata or, providing the ESI as it is, and the judge has no clue what you're talking about and denies your motion. You're like, no, this is very important to this case. So I think it's going to be really important also just educating the jurists on how to handle these things.
Right. And there's some tension here. There's not only the supervisory obligation, but we have an obligation of competence, right? We haven't talked much about.
Yeah, there was a change made, again, for those of you who aren't familiar with it, in 2012, there was a change made to 1.1, the rule that says we all have to be competent as practicing lawyers. Comment 8 was amended to say that whereas you got to stay abreast of changes in the law, the phrase was added, and also changes in technology was added. And as I said, that's up to about 35 states now that have adopted that comment. And what does that mean? When you think about a duty of care that we all have, we're fiduciaries when we practice. We have a duty of care to our clients. I'll go ahead and pick up on the question I raised before. At what point is the failure to use a tool or the improper use of a tool malpractice? I was talking to Dean earlier, and I told this story when I first got involved in e-discovery back in 2003. I did a program with a consultant who afterwards became a good friend of mine, but I said to him, well, what are you spending most of your time on these days? And he said, oh, malpractice lawsuits. I said, oh, really? He said, yeah, I've got 7 of them. I'm an expert in 7 malpractice suits. This was, for the young lawyers in the room, was right around the time when we were sort of moving into the discovery world in a big time way. And one of his cases was there was a company that would tagged image file format, do TIFF images of documents for discovery. And he had a good friend who was a lawyer and said, I need some business. If you ever have a matter where you need TIFF imaging, give me a call. And so the lawyer hired him for a case. $1 million later, all the images were created and the client refused to pay the bill. And my buddy, the expert, gave the following testimony in front of the state court judge in California. Your Honor, for $350, I could have bought a hard drive and downloaded all those same documents in native format and given the drive over to the other side. versus the $1 million. And so versions of that, I think we'll see whatever the fact pattern is in the future, we can conjure them up as we talk about these different tools you're hearing about today. But there will be versions of that, and lawyers will either be blamed for not using them or be blamed for using them incorrectly. And when this also gets into the area of communication with clients, Rule 1.4, for those of you who care about the rule number, but you have to keep clients informed and where appropriate, get informed consent. But yes, competence is critical here. You can't supervise if you're not competent. You can't act on behalf of your clients in certain of these arenas if you're not competent. And so I would not touch some of the things I've already heard about today because I'm not competent, but I would retain somebody within my firm or an expert to help me. That's okay. There's actually ethics opinions out there that say if you're not competent, you need to get up to speed yourself or have someone helping you, and then you can satisfy your obligations.
And I think we'll see increasing conflict between the obligation of relating to Rule 1.5 of not charging unreasonable fees, right? So if the tool is available, do we need to be using it to bring fees down? Versus competence and supervision, which is a challenge in the other direction if we're lawyers and we didn't go to tech school before we went to law school. So there's maybe a foreshadowing of a change to the whole
So
practice of
you
law.
raised a different question. I'm interested in the audience's reaction to this. So I've got 20 lawyers that I have on staff doing contract review. I can replace 15 of them with a software tool and save clients money. But that means I'm going to make a little bit less money because I can't bill all these lawyers. So what do I do? What do I do? Do I replace the lawyers with the software tool, or do I only do that for clients that are sophisticated enough to know that I can replace them with the software tool, but continue to use them for clients that aren't asking those kinds of questions? And what do you think, what kind of decisions do you think lawyers are making out there?
You replace them and with the tool, but you create economies of scale so that you get more business and are able to continue employing the lawyers. And
So that is one answer. Do you think that's the answer that every lawyer in America would give? I don't know about that.
Well, I do think, though, the pivot is important here. For those lawyers who've already pivoted into a more technical practice, there's far more work than there are attorneys who are able to do the work. So for those of us in this area of practice, we are desperately looking for formed ways of in smoothing the intake process. For me, project management tools that better enable my legal project management, that help me make decision making based on when I've had successful breaches or criteria of successful breaches. Radar, which is a tool that automates the state and federal breach response process, not perfectly, but it helps automate the legal analysis. So I would say there's a spectrum of lawyers, and for those who've had to pivot into an extremely legally starved area, we're ripe for help, and we're trying to innovate to try to keep up with the speed of our clients.
Well, I take that point, but most of what happens in law today is litigation. That's what so many lawyers work on, and there are ample numbers of lawyers out there. I've had folks walk into my office and say, do you need any help in reviewing documents? Because we can give us 2 hours notice and we'll have 50 lawyers available to do document review for you, outside vendors. So there are lots of folks out there. There are specialized areas, no question, where there's a dearth of talent. I concede that. But in the litigation field, in the space that Julie's company is in, she's there trying to make life better for lawyers, make life cheaper for clients. But there is a genuine tension there between the economics of law from the lawyer's perspective and the economics of law from the client's perspective. And it's just something always to be aware of. Hey, look, I'm always of the view you do your best to save clients money. I agree with everyone on the panel. That's what we all ought to be doing. But don't underestimate the economic impact of losing billers to a software tool.
Yeah, absolutely.
I also, something that Amy and I were talking about earlier in preparation for this, and you brought it up about a good lawyer has experience, knowledge, and judgment. And while AI can, kind of fill in that knowledge gap, You don't get the experience as a first year associate if you're not doing the doc review, if you're not in those documents, if you're not getting to see all these different types of materials. So I think you also lose something there when you have this being done on a larger scale and you don't have lawyers actually in the grind at the very beginning learning that. And I know some people are probably cringing that I'm saying that, but I think it's an important part of the process.
Back to your point on the economic impact, however, I think part of the reality is firms have to understand the economics. They have to understand that there's profitability and there's gross revenue. And that if you start to look at profitability, you're going to have a competitive advantage, and the competitive advantage is going to win out in the end because your competitors are going to see your competitive advantage and change.
So my reaction to that, Dean, is you're really talking about the new model of a law firm. The law firm 10 years from now, 15 years from now, 20 years from now, where there will be fewer associate types, more staff lawyer types perhaps, but the offices will be configured differently. You won't need as much space. You may have people telecommuting. In fact, one of the issues we're looking at on the standing committee is the issue of whether or not you have to be resident in New York. If you live in Florida, is there any reason why you can't practice, and your New York license, is there any reason why you can't practice from Miami if you have a New York license and there's a computer in a New York office that belongs to you whenever you show up in New York? There's this issue of telecommuting is a very big deal right now, and we're looking at issuing an opinion on that. But the future law office, there'll be all these automation tools that you've heard about, whether it's related to contract review, figuring out data breach requirements in the various states. Again, whatever can be automated will be automated. Who's the folks down the street from your town at Georgetown where they automated all the executive compensation agreements that are on file with the SEC? So if you're doing an executive compensation agreement, you're going to run that agreement through that software tool to figure out if somebody's come up with a better clause than you drafted. And at what point you have to do that, really, is the way I look at that one. You can't offer an executive compensation agreement without looking at that tool. So the law office of the future will be lots and lots of software, smaller office space, and looking for profitability, as you say, using these tools, as opposed to lawyers making money for you. It's software tools making money for you, and probably fewer lawyers, because you're going to try to bring down your overall costs.
So let's talk about how well that software works and whether we're really improving the practice of law or whether we're simply shifting the practice of law.
I'm sorry to do this, but I have a 96-year-old father. Whenever he calls me, I always pick up the phone.
Go right ahead. So Nicholas showed slides earlier today that showed that in the e-discovery world, when results of automated document review were measured, it turned out that there was a really wild variation in how well the law firms and tools, or combination of the two, had done, right? And so there were results where 80% of the information that was supposed to be found, the relevant information, 80% of that information was identified. And there were results on the slide where 2% of the relevant information was identified. And to the extent that lawyers are giving advice on facts, which is what we do, it's fact-based, the ability and inability to find the facts that matter is going to affect the quality of the advice we're giving. And it goes back to whether we're competently practicing if we're using tools where we can't find the information we're supposed to be advising on. And I would suppose that as we move into contract review and some of the other tools we're using, we're picking a jurisdiction for a case because of the algorithm that tells us that the best jurisdiction is in and around Miami. What if we've run that badly, or it's based on faulty data? We've now advised that we file a case in Miami, and that was really a horrible mistake. Right? There are algorithmic tools that are supposedly being used now to predict who would be the best, it's kind of a different point, but who would be the best judge That's the same point. And who would be the best presenter of a case? As those tools are, the flaws in those tools can affect outcomes.
So here's a flaw for you. You file a case in Miami because you think you're going to get the right judge, and then a new judge is appointed to the bench, and the judge that you ended up getting that you're so happy with based on your algorithmic analysis transfers the case to the new judge who you have no doubt on. There's no perfect solution here. I mean, at the end of the day, when you're trying to do these kinds of things, honestly, it's...
So you would say we shouldn't be worried for malpractice if we use the tools badly.
Well, you have to be, what you have to do is explain, is get yourself protected in terms of communications with the client.
Yeah, there's an interesting little case in New York, small real estate matter, where the technology, high-tech technology being used by the individual practitioner was AOL email. And the AOL email was hacked, and the hacker masqueraded as the attorney for the seller of real estate, because it was a real estate transaction worth several $1 million. And the hacker emailed the purchaser and said, send me the down payment, here's the bank account number, send me the $2 million down payment, and then we'll be, good to move forward with the transaction. Meanwhile, the lawyer doesn't know that this email exchange is happening because the lawyer doesn't have the tech savvy, right? So the purchaser makes the down payment, $2 million goes off to the hacker, and there are risks. Yes, the lawyer lost for having inadequate competence to manage the high-tech email system that was being used to transact business. So,
Yeah, but admittedly, wire transfer fraud is so common. And I'm sure we're going to have other permutations in AI as well. But, what I worry about and help my clients with when we're advising is how do we develop reasonable evidence? We can't expect perfection, but how do we develop reasonable evidence that we've examined as many permutations of issues as possible? And I think, I kind of hearken back to where we were in cybersecurity 20 years ago. Everyone was flying by the seat of their pants, talking about security by design, talking about privacy by design, but no one was actually doing it and implementing it into their project management processes. Project management, in big corporations is how, you go from an idea to an actual product. Now, it's not perfect. Nothing is perfect. We're still very far from perfect. But we at least have, in major project management tools like Jira, interfaces to assist us with considering security at stages within the project management process. We will likely get to a more sophisticated point, even in cybersecurity, but a more sophisticated point in evaluating algorithmic tools, because we need to systematize and develop the evidence as lawyers that our clients have done a good job evaluating their initial whiteboarding, their algorithmic development, their training data, their quality assurance once they've put their training data to develop their algorithms, and then ultimately various stages of their outputted data. So I think that is the process that as lawyers we need to suss out. And I'm going to be a bit contrarian here. I don't think we're going to put a ton of lawyers out of business. I think we're going to be thinking deeper. I think it's going to be an interesting place in the law. And especially since we have a lot of law students in the room, you can get really inspired about the velocity of data that we have and the depth of thought that the next 20 years will bring.
So Amy, should the law school curriculums change? Should we have changed curriculums? What sorts of courses should be offered in your view?
In my view, we have, because we have lawyers who won't get to see as much of the judgment process as I've been a part of, lower level litigation, document review. Perhaps our clinicals need to prepare our lawyers for that new reality. So, I am not an expert, I think, in legal education. I took my 3 years and ran with it. But I do think that our education system needs to be very much not just focused on developing good analytic abilities. That will always be necessary. But we really do need to think about how do we start to give our junior lawyers and our budding junior lawyers the clinical practice that they may miss out on initially because we've automated some of these functions.
I think we also need to add enough required course to the curriculum to teach us what we don't know about things outside the law, like the technology, the algorithms, the outputs, the differences in measurement. It's so alluring to point a tool at something and get a result and believe with blind faith that the result must be good, right? Because after all, you bought the algorithm, everybody's got this on their phones, right? You're bringing down apps and you assume they worked. We get in cars with strangers because there's an app for it, right, called Uber or Lyft. And it's sort of changing how we think. If there's an app, it must be good. And we know that's not true. Nicholas has established that well, and or NIST did, and as well established with the data on the ability of participants to predict how well they did, that we can't predict. We're not good at this. So we need statisticians. We need, as the tools develop, I don't know what other competencies we need, but I should come out of law school knowing what other competencies I should be calling on. I should be aware of what I don't know when I get out of law school.
It's not happening quickly, I can assure you.
There are whole libraries of things I don't know, so it's a pretty big burden on law schools to teach me everything I don't know. What I would say is some basic technical expertise would be good. I do think when we hear about NIST, if you look at machine learning technology, the reality is the data that it's trained on the model is what's used to predict accuracy. When you introduce new and different data, you may have a very different result, which is why you could see a very different accuracy. That's one issue. Another issue is that it's called model shift. And so data changes in unpredictable ways. And we could sit down and run that tool today and get 99% accuracy. And 5 years from now, we could run that tool and get 70% accuracy without changing a thing other than the data will be different than it was. And so it's not just the technology, it's the reality that the data changes as well.
Sure. If you put that, I don't want to go back in terms of teaching us what we don't know. It's not making us learn the content. It's making us aware that there is content that we don't know. And we learn that in law school by taking lots of different classes and seeing on the curriculum all kinds of classes we don't have time to take. And we think, oh, I guess there must be employment law specialties out there and specialists. So if I have an employment question, I better call John because I didn't take that course. I didn't have time.
Yeah.
Right? So we become aware, and we're not becoming aware right now of the technology change that is a world we don't know. We just need to be aware of it. Good.
I would add too that it's not just, believe me, I love the shtick of we need more technical lawyers. That is my daily bread. But I think what's the interesting piece of AI is we also need more social scientists, more ethicists. It's not just understanding the base technology, but I think there's a real and lovely opportunity for legal thought and various different discipline of thought integration.
So you really take it into the world where you're serving as an advisor to the client, and the client is working with technologies or building technologies, right?
Absolutely.
Go ahead.
One of the, Julie and I were just talking aside, one of the cases that I would love to see and is, what does the new FTC substantiation look like for an AI tool? Let's really get our hands dirty and see, what type of statistical substantiation do you need over time to show whether or not the advertising that you're doing regarding the outputted algorithms for particular data, to what degree of accuracy do you need for those marketing claims? I think that would be a fun case. Maybe it's a little bit geeky, but I think it'd be a lot of fun. And that's not only going to take lawyer technologists. Depending upon the subject matter of the data that is being processed, and it's not just the algorithms. Know that there are companies that just provide the intelligence without regard to the data itself. But we, depending on the subject matter that we're looking in, we may need different social scientist integrators. So I hope that gives those who have a technology bent some heart, but also those who have a social science background, a statistics background. You are definitely welcome within this club.
You raised the question of how well you have to do, and the Loomis trial we just watched, I would say, took the position that as long as you've disclosed that you didn't do well, wouldn't do well, were biased, and shouldn't be used, as long as you disclose that, and we could argue whether it was disclosed clearly in the user manual or not disclosed clearly, maybe you should be off the hook. Right? So maybe the tools just have to, maybe it's a question of how well they disclose their frailty.
Can I sort of follow up on that theme with a slightly different twist and look at juror research and artificial intelligence? Anybody in the room familiar with Judge Alsup's opinion in Oracle versus Google, Northern District of California a couple of years ago? No. So Oracle versus Google, that sounds like companies that could certainly mine big data without a whole lot of difficulty. And they requested a couple of days notice before the jury was going to be voir dired, and after they got the list of jurors' names. And Judge Alsup couldn't figure out why they wanted 48 hours time. And then all of a sudden he figured it out. They're going to be doing juror research. And when they questioned the jurors, they wanted to have a dossier on each juror. Now, normally in federal court, the judges handle voir dire and the lawyers don't. But Judge Alsup, in this case, because it was very technical, very large, he told the lawyers he was going to allow them to do a lot of the voir dire. But he wasn't happy about the idea that his jury pool would be subjected to juror research. So he asked the lawyers to forbear from doing the research. And the Google lawyers agreed, and the Oracle lawyers didn't agree. And so he decided that he would advise the jury pool when they entered that there was going to be, he was not going to allow them the time, but he would allow the jury to change all the privacy settings on any of their social media accounts, and then come back into the courtroom and then be voir dired. And then Oracle decided that it would agree with the judge's suggestion not to do any of the research at all, and went to trial. I don't remember who won, but Judge Alsup issued a very interesting opinion, which caught my eye, because here's what he was worried about. And think about this in terms of the trials of the future. He was concerned that a lawyer, and this goes to your social scientist point, a lawyer would learn enough about a juror, forget voir dire, after the jury was already set, would learn enough about a juror to know what mattered to that juror, and then would frame questions during either direct examination or cross-examination designed to appeal to a particular view or prejudice or bias or whatever of that juror. And no one would know about it. And when you read his opinion and you look at the citations that he uses, he cites to prosecutor cases where, in closing argument, prosecutor inflamed the jury with some statement that prompted the Court of Appeals to reverse because the jury wasn't making a determination on the basis of the facts, was making a determination on the basis of the prejudice that the prosecutor inspired. And he was saying in the future, this could get so subtle that courts wouldn't even know it was occurring. And jurors may be rendering decisions not based on the facts of the case and the law and the instructions given to the jury, but on an individual's personal views or biases. Now, that's a little scary to me. It was certainly scary to him, to the point where he wrote an opinion raising this concern. Now, I've not seen anybody follow up on it so much, but there's no question that a form of it goes on when we conduct jury exercises, right? We do it all the time. My firm is basically a trial firm, and we do jury exercises. We have them going on constantly. Learning from jurors, well, it's just another little.
Just to make sure, John, just to make sure everybody follows what that is.
A jury exercise.
You bring in a
jury exercise is you hire a consultant to find folks in the community to sit and hear your evidence. You'll play video depositions. You'll have somebody actually stand up and make arguments in front of the mock jury, and then they'll fill out a questionnaire and give you insights as to whether or not they like this witness or didn't like this witness, or they like this argument or didn't like this argument, or if they found this persuasive or not persuasive. Well, artificial intelligence to learn about jurors, the actual jurors, not the mock jurors, is the next phase. It's probably occurring as I sit here today.
Yeah.
I mean, I'd be shocked if it isn't.
I mean, I would say it's already happening on a smaller scale. When I would go out and pick a jury, I would pray that I would get to lunchtime so I could run back to the office, and I would Google every single one of those potential jurors, and I would find everything that I could.
Well, now imagine that you're in the courtroom, you're not at lunch hour, and someone has just emailed you an entire dossier on every juror, and 10 minutes after the trial starts, or after the jury's been selected.
I would say that was good lawyering.
Yeah, well, I realize that.
I
That's
mean,
the argument.
I would as a
All right,
trial.
so let's carry that point further, Justine. It's good lawyering to you. The lawyer on the other side doesn't have that capability. Can't afford it, client can't afford it. Defendants can afford it, maybe plaintiffs can't. Does that matter? Should it matter?
I think it matters on the type of case, right? I think it matters.
You expressed a concern about access to justice.
Yes, that's why I said I think it matters on a certain type of case. I think if we're talking in the context of criminal cases, if we're talking in the context of
Should judges
family-
bar the practice? Should judges level the playing field and say nobody can do jury research?
I think when it comes to money and corporations, I would say no. I think when it comes to the criminal context, and I think that's why the judge cited a prosecutorial case. I think there's a difference.
But it was in a civil setting. It was Oracle versus Google, and the judge was worried about it.
Yeah, I get it. I'm just saying, in practice, I think it's great lawyering. I mean, I think there may be a limit. I think there may be a time where eventually you may have to end up disclosing what you know about the person if it gets to that point. But I know it has been very effective to, when you're going in to pick a jury, there's going to be bias. Everyone has bias. So even the way I dress, the way I talk, what I put on, what I do, that is a part of the bias of what the jury is thinking about me. The way, what I look like, the color of my skin, my hair, my height, my weight, all those different things. I think knowing that information is out there and using that information, I think it's good lawyering.
So just there are ethics opinions on whether or not if you access a particular platform and that platform sends a notice to the individual that someone's looking you up, is that an improper communication with the juror under the model rules that prohibit communications, ex parte communications with jurors? There's two opinions in this state. The city and state bar of New York both have indicated that could well be of communication in violation of the rules. The ABA, the committee I'm on, not when I was on it, but issued an opinion saying that if it's a purely passive inquiry, even if the platform sends a notice to the individual, you're not engaging in a communication. But there again, you see where you have to know your jurisdiction and pay attention to these rules. But I don't have the answers. I just know that where this is going is in an arena where folks that have the wherewithal to try to gain an advantage by learning more about those jurors will likely be making arguments that appeal to the jurors when no one in the courtroom may even be aware that that's what they're doing.
Interesting.
Yes, a question?
No,
Make the point that I think the wherewithal is diminishing every day because the ability to obtain this information is easier to find and less expensive to have.
No, I don't know if everyone heard the comment, but I actually have a friend that just invested in a company to provide juror research like I've just described to Justina instantly once a jury's picked for a fee, so that you're right. You can go to a company like that, and maybe that will level the playing field in time, that kind of service will be available.
Yeah.
It's a changing world, folks. It's a changing world.
Yeah, I think, John, for some of your clients, we need to teach them how to use private browsing for LinkedIn, so they don't appear.
Exactly. Or log out before you
Yes,
let the person up.
Absolutely. And I would just like to take this a little bit of another intellectual step further. Would folks in this room have problems with, us going online, doing a search of someone's public social media page, finding out that they're a neo-Nazi? trying to restrict them from the juror pool based on that fact. Because we could even exclude them from the jury if you get the information soon enough.
Okay, can you put up the receptionist or anybody else in your office who happens to know a potential juror, or say a witness who's going to be deposed shortly, to friend a person in order to gain access to the private information as opposed to whatever is publicly available? Is that ethically permissible to put up someone to, on the pretense of friending, but really to learn enough to be able to depose that witness or examine that witness at trial in the future?
I think, do you want to answer, so you're waiting for the audience to answer?
Well, I mean, who says that's okay? Gumshoe detective work, or is it deceitful? Who says it's gumshoe detective work and it's okay? Oh, no one's going to be bold enough to run that risk.
Be bold. There is no penalties. There's no malpractice here.
Yeah, well, I mean, the ethics opinions roughly now 10-2 say that's deceitful. Both New York and Oregon say if the person's willing to allow the friend request, then what's wrong with it? But every other jurisdiction that's looked at this question has said, and I don't know in New York whether it's the city, the county, or state, I don't remember. But every other jurisdiction has said that's deceitful. 8.4 says you can't engage in conduct that represents fraud or misrepresentation or deceit. And you got to be truthful to third parties. That's a 4.1 obligation. And these ethics opinions have said, you can't do it without telling who you are and who you represent and why you want to do it. But, again, there's a line between dissemblance and deceit. You can send somebody in to a landlord because you're going to bring a housing discrimination case under false pretenses to rent an apartment, and if he or she is black and is turned down, that may become your evidence. Many courts have said dissemblance is okay, deceit is not. So, another form of the use of these tools by lawyers. There are ethical consequences here, and so many of them are going to be fact dependent. But, we're covering a lot of ground here in a wide survey.
Right. We might switch it slightly to discrimination, bias. Loomis obviously raised those questions. We heard about them at some length. What do we think as lawyers when we're using these tools? So I'm sort of switching, John, a little bit from where you were.
Sure.
But I want to make sure we have time to talk about this topic. So, go ahead.
I think it's unknown right now. I think that using these type of tools can be beneficial in helping to eliminate bias, but I think there's going to have to be a lot of hard work to get there because the algorithms and these tools are made with data that's most likely inherently biased. So I think that that's something that we're going to have to do. The good thing though is machines are consistent. So they're consistent. When they put that data out, that data can be reviewed, but we just have to always remember that consistency doesn't equal fairness and it doesn't equal justice. So I think as long as, I remember earlier you mentioned like ethicists and auditors, as long as it's something that we're constantly reviewing, I think it could be a great tool to help eliminate bias in some of these areas.
The couple of panelists from big companies earlier today, I think were advocating that we should just break down some of the barriers to getting at everybody's data, because then we'd have unbiased data because it would all be available. So, is that a solution for lawyers? Sorry, I don't mean to laugh.
Well, I don't want to predict gloom and doom. It's not within my capability. But I think the commercial applications are pretty amazing and astounding. I had the benefit of working with a major home automation platform. And a portion of what I do is cybersecurity, and a component of that is child protection. And we were working with the home automation platform on the linguistics that may indicate the propensity for a child or an adult to ask questions regarding abuse. And when does the home automation tool have an obligation to report to the local authorities that there are signs of potential abuse within a household, given the questions that are being presented to it? That is scary on one level, but it is amazing on another level for the child or the wife or the husband that is the constant subject of abuse. So, even though we ultimately may have extremely biased training data that we need to compensate for, we have issues with regard to the algorithms, we have multi-staged issues with outputted data, even while we're in the beginning, middle, and end stages and constant stages of learning. The commercial applications and the deep thinking that we're starting to do, I think is for me, the reason why I get up every day.
Actually the same people who are advocating for full and free access to everyone's data, we're also talking about how much easier it would be for the lawyers to weigh in and have an impact if we were weighing in at the beginning of a process as opposed to way down the line when the
Yes.
product's ready to go out the door. And I'm curious, the lawyers in the room probably have varied experiences about how often their clients welcome them to come in and tell them that their ideas have problems. And how do we get into the conversation early enough to have that impact before the client's going to be mad that we're raining on their parade and they'll tell us they're not worried, they'll take the risk anyway.
And if I might add a permutation of that, and then I'm going to shut up and let other people talk. At least the algorithm development may be a different intelligence provider than the company that ultimately provides the data sets. So quite often we're dealing with compartmentalized knowledge and black boxes. So that's my daily problem. I don't know if it's yours as well, Dean.
That's one of them.
Yeah, I mean, many, right?
Yeah, I think there's a lot of concern around bias, and rightfully so. I think that in the criminal justice system, the use of AI raises another potential issue, and that is machine learning finds correlations in data. It doesn't make judgments, it finds correlations in data. And so when you look at, for example, predicting risk of recidivism, there's a lot of research that male children raised without a father are more likely to commit crimes. A machine learning algorithm that considers that data is going to increase the likelihood of an individual, a male, raised without a father in their life of committing crime, because statistically that's true. But our whole criminal justice system is we don't punish people for who they are, for their immutable characteristics. We punish them for what they've done. So if we're going to include, even if it's completely unbiased, if we're going to include characteristics in the data features of the AI in the criminal justice system, there is that risk that, in fact, you could create a system that discriminates against people based on who they are, not necessarily race or other protected class, based upon perhaps their growing up in a poor community where there are more markers that statistically indicate you would be more likely to commit a crime.
And even worse and even harder is the question of, sort of what happened before that conviction. What was the bias in the community that might have made a conviction more likely for an action that if you were a different ethnic group, you perhaps would not have been convicted for. And so the algorithm might tell you the convictions are more likely, but that actually wouldn't tell you whether those convictions were fair.
Mm-hmm. That's exactly what that was going to be my point. I was going to say it's like the chicken is the chicken or the egg kind of thing, where I think what the nice thing though is with the algorithms is that we can acknowledge that, and maybe, just maybe, we can control for it. That's the beauty of social science and the beauty of technology. Maybe we can figure out a way to say, okay, we acknowledge that the data we already have has that in it. Can we now, control for that and make the machines more effective and make them an instrumentality of justice?
If I can just add, I sit as an arbitrator a lot in technology cases, and Julie mentioned I was a special master. I've been serving as a special master overseeing the consent decree that governs the multi-billion-dollar restoration of the Florida Everglades for the last 15 years. And I've had several hearings where I've heard nothing but experts. But the point I want to make is you, as a trial lawyer in any one of these cases, and I'll go back to competence, you have to work very hard to explain if you think something is wrong, if the algorithm is in fact biased and you're trying to prove that, you have to be able to explain this to triers of fact, and I'll forget juries. Let's just assume it's a bench trial, to judges who, for the most part, are going to be clueless. And it takes incredible preparation, incredible talent to be able to explain complex terms, how things work, bits and bytes, how things work, to folks who have no idea what you're talking about and don't come across these kinds of things in their day-to-day lives. Most of the judges that we still have on the bench today are relatively unsophisticated from a technological standpoint. And so I urge, particularly the younger lawyers in the room who are interested in getting into litigation, trial lawyering, to be mindful of the learning curve that it takes to be able to explain how things work. It's a real challenge. And remember, just to dumb things down to a point where you could explain them simply to a court, it takes enormous preparation. Because I've had many lawyers appear in front of me trying to explain things and that I knew better than they did because of when I get hired as an arbitrator, it's because of my technical knowledge of whatever field it is. But you're not going to get that with a judge, is the point.
Absolutely. I've admittedly, that when I was a young lawyer and an associate, literally made a business out of learning things that nobody wanted to learn. But still find in my day-to-day law practice that even the lawyers that you are associated with, even in your own field, some of them became lawyers because they did not want to be technical. So the more that you're, even if you don't have a technical background, to the degree that you can have a translating role and at least have an intellectual curiosity, that is an extremely marketable skill.
Right. Maybe the law firm of tomorrow and maybe the corporation of tomorrow need to look, more similar in terms of the additional skill sets that are brought in, right? Because we've heard social science, we've heard, I'll say statisticians if we didn't say it before, computer scientists. Dean, you've obviously brought that to your firm. But
Really, when I started practicing law, we used carbon paper. And when I went and did discovery, I still remember the worst experience in a warehouse in Merced, California for 3 days, no heat. But I had to rent a copy machine. Well, those days are long gone. And the discovery in the future is going to change as well as machines get better and better at it. Instead of having staff lawyers turning pages, you'll have very, very smart associates figuring out how to mine data in ways that are much more clever than they're implementing today. But it's hard to do things by yourself anymore, is the point. Really hard to do things. When I could do anything I wanted to do as a trial lawyer 40 years ago when I started practicing law. Now I need help. Just to have the person, when I call up the document, all of a sudden the document appears on the screen in technologically developed courtrooms. But there are lots of courtrooms in America that have no technology either. So you can see there's a lot of variability.
Have no outlets.
Have no outlets. There you go. There's 50 states in this country. They're not all the same.
I'd like to spend a couple minutes on the non-consumer. Loomis raised the question of the algorithm propagator, as it were, disclosed, they say, in their user manual, the biases, the risks, the fact you shouldn't really use the algorithm for sentencing, et cetera. So the court system that purchased that algorithm theoretically had all that information. Loomis didn't have a say in that, right? When Amy's client, makes a nice algorithm that Dean's client buys and puts into a robot that they then sell to a delivery company to deliver packages, and the algorithm, which keeps learning, understands and learns that the fastest way to deliver the most packages is to walk in a straight line from the front door of one house to the front door of another. And the person in between, because in fact there's a house in between those two houses, right? It's through their flower beds and their greenery and flowers get trampled, right? That the person who dealt with UPS and agreed, or sorry, the delivery company, and agreed to accept packages by robot, which I'm sure was disclosed somewhere in some fine print that they didn't read. But they had a choice, right? They had a choice to read the terms, not read the terms. Suppose the delivery company made full disclosure. How about the house in the middle, right? Which was right in the straight line that the algorithm learned was the fastest way to deliver the most packages. Who's responsible? They had no choice. And you can imagine scenarios that are a lot more life-threatening than your flower bed.
Well, you have the actual Tesla example in Florida, the first fatality. So Tesla, a gentleman in Florida, got into his Tesla, put it in autopilot, got out his Harry Potter movie, and was watching the Harry Potter movie, and the car slammed into a truck, and he was killed instantly. And the National Highway Safety Commission investigated on that very question, was this a defective product? And the answer was, he had notice. Because the question is it unreasonably dangerous for a consumer? And if it's dangerous and you have notice, then it's not unreasonably dangerous. And because he had notice, it was not unreasonably dangerous.
Suppose the Tesla had hit someone else and killed them. They didn't have notice.
That's true.
But Julie, we're not going to change basic tort law in America. It's duty, breach of duty, proximate cause, and damage. You can change the fact patterns. You can create the new tools, the new devices, the new instruments, whatever they are, the devices. But ultimately, jurors are going to determine whether or not someone was negligent in design, negligent in implementation or handling or operation. And if something is unreasonably dangerous, or if it's not unreasonably dangerous and therefore strict liability should apply versus a form of negligence should apply. Those principles have survived hundreds of years as the industrial age has advanced to where we are into an information age. It's not going to, the principles aren't going to change.
So you're telling me that the legal system is sufficient for this, and we do see, people using Trespass to go after companies that have scraped data off their website and slowed down how their website worked. And those of you who went to law school, have been to law school, know that Trespass was something you studied once really early and haven't heard from since. But there is a question, I think, whether the notice might need to change. The duty is something that can change with the times. And it may be that as we're launching more robots and drones and products that, I was at a doctor's office and the beeping sound in the background, the doctor walked in and said, "Alexa, turn off the timer." And I thought, well, that's a problem, right? Because Alexa is sitting in my doctor's appointment and the doctor doesn't know that that's a problem, but I do, right? But how about if I didn't, right? What kinds of notices might have to be to the non-consumer who didn't have a choice? John?
I just want to put it, John, to your point, where we have things like the workers' comp, where you change the rules of the game with a certain situation.
Oh, this Christian.
Might it not be the case in an autonomous vehicle situation that we decide societally?
It's Christian too. I'm sorry, I said the wrong thing.
No, I was just going to ask, do you not think it might be the case that we might be in a position, vis-a-vis autonomous vehicles or something, that we decide in terms of how the risks are brought to bear, where the benefits are, so that you can make economic calculus and whatever else, or the societal benefits might outweigh? You don't provide for any situation where we might actually change those long-lasting rules of the game that you mentioned from a tort perspective.
So
I think that's the key question here. Isn't it?
So take nuclear power. We have a Price-Anderson Act. Congress can certainly, or a state can certainly create, alter liability rules. A legislature, so the public through the legislature can make those kinds of policy determinations. I agree. If something's really valuable to a society, blood transfusions and transmission of AIDS, you want to encourage people to deliver blood, to give, and so you can, yes, legislatures can do that, but I don't think courts can.
Yeah.
I don't see courts doing that.
I want to add one point. the strict liability is one tool that a legislature has in its toolkit. It's also very important to make sure that we remain cognizant of statutory damages, legal provisions, and the cybersecurity and privacy world. You as a company, people begin to stand up and take notice where there are statutes that have statutory damages attached to a statute, creating either large regulatory classes or consumer class actions. So there are a wide variety of ways that we could see the regulation of this industry. I think this industry is way too nascent, though, to take that step.
Just a small point on what we've been talking about. I suspect that the change in last year's tax law will encourage law firms to develop separate organizations for the collection of material but somewhat unrelated data and information for the use of the courts, which will change very markedly their end day on tax payments.
Okay.
We'll see.
May I ask a question? What?
Timothy has a
I
microphone.
know. One more question. Right.
Yes, and,
We can't
I
answer
have a question for the panelists. So what would you hope that judges know with the automation of the legal industry itself? What would you want judges to know that you're going to go into ahead in order to be more prepared for this coming wave of automation?
Well, I can give you one reaction. The Federal Judicial
just
Center does
repeat-
do training.
Repeat the question of what we'd want judges to know.
Yeah, so the Federal Judicial Center does do training, and they published a manual on science issues for federal judges. So it's conceivable that a group coming out of this organization could go to the Federal Judicial Center, and I see that James Duff is supposed, is he here?
Well, I'm from the Federal Judicial Center.
Okay, you're with me. All right.
I'm asking you.
All right, very good. I didn't realize that. Well, I just spent 7 years on the Advisory Committee on Civil Rules, so I'm very familiar with the Federal Judicial Center. I would encourage you to work with this organization and see if you could develop a set of principles on artificial intelligence, basic terms, a glossary, that then could be provided to federal judges throughout America, just like your science manual, which is a very helpful document. I think that would be a terrific service to the judges. And then the state Supreme Court justices would pick that up and distribute it to the state judges. But education is very, very important here, absolutely.
And we'd like to teach them, I think, how to ask questions to find out the results of algorithms and how to evaluate those.
And also, as a mother too, walk before you run. So I would want people to ask good questions regarding the systems that are available within a company, so they can ensure that a fulsome search has been done at the outset. Because in addition to the quality and control of the algorithms, we still also might have some selection bias regarding what systems are being presented for review.
Okay, so thank you very much, Julie. Thanks for the...
Will you just indulge me with 30 seconds for one more trick?
Yes.
One more trick. It's just because I need to leave you with at least one piece of advice, which is, in law, you get just one bite at the apple. But a juggler gets more than one bite. But what I want you to remember is never drop the ball. Remember that.
Awesome. Thank you.